A very good afternoon to all my dearest student friends. So, in continuation to our last class discussion, today we are going to deliberate on your bargaining structure, your bargaining process, and the agreements, where we will cover the introduction part, we'll cover the bargaining process and the settlements and whatever collective agreements one will go for, and what are the conditions for success of bargaining apart from some kind of self assessment which we'll make at the end of the deliberation. So after hearing this session, the students will be able to explain the steps in the bargaining process, and students will be able to understand the legal connotations of the world settlement and what are the various principles in it. And apart from that also, the students will be able to identify the list of items and the guidelines in collective agreements. So let us give a befitting introduction to the entire theme. So as we discuss the collective bargaining, which is a flexible concept and it is natural, some kind of, you can say, give and take before the final agreement is reached, and or you may say that the final agreement is arrived at. So it provides a kind of mechanism for your organized relationship. And when we are talking of the relationship, it is the relationship between management and the trade union. So in fact, the heart of the collective bargaining is the process, and it is a process of, you may say, the process meant for continuing joint consultations. And in fact, there you will have some kind of adjustments, and it is the adjustment of various problems and those problems of the organizations itself. So basically, it is demarcative and it is self-government in action. So it has been characterized as a form of, you can say, industrial democracy. It is some form of your industrial government. So it is not a competitive process, I must make it more clear, but essentially it is complementary one. And having said that, it is a process, and it is a process of, you can say, social change, where you have some kind of peace treaty which is undertaken between two parties, and that too in mutual conflict, the parties which are in mutual conflict. And there is a system of industrial jurisprudence. Normally, what will happen that the collective agreements, when it is reached between the parties, and it is broadly covering matters, and those matters relating to either employment or matters relating to your working conditions. So the nature and the course of collective bargaining are heavily influenced by some kind of legal framework. And the effective administration, if you look at the effective administration of collective bargaining, that is also very, very vital to the health of the union management relationship, because we would like to maintain healthy relationship, we would like to restore good relationship between the management and the union. But for some issues, collective bargaining occurs when one party's goal is in conflict with those of the other party. So for that process, one has to touch upon bargaining process. So when we are talking of bargaining process, obviously from the collective bargaining point of view, so collective bargaining is a two-edged sword. So when I say two-edged, so what is owned by what is owned may also be lost. So today's collective bargaining, if I'm talking of, it is a process which is based upon some kind of a statutory law. So question arises that what makes collective bargaining possible in this context? So collective bargaining in this context is that your labor and your management, they have an ultimate harmony of interest. The desire to assure that the farm for which they work, and apart from that, also what we look for, from which both both of them they are paid, will remain in business. So in order to stay in business, it must be competitive with other farms. So the bargaining process includes some kind of preparation, and that too preparation of initial demands. It includes your negotiations, and finally you have settlement. So obviously, what is the need of the hour? That need of the hour is going for adequate preparation. Adequate preparation for bargaining is often, I would say, the key to success. So you'll have preparation for negotiation, and this preparation for negotiation is a comprehensive, ongoing job for both your management and the union. Because if you go for preparation, in fact, preparation allows each bargaining team this will allow each bargaining team to go for to determine what is the objective of their bargaining, what is the bargaining objectives. So you'll have a negotiating team, and what would be the job of the negotiating team? The negotiating team to defend its proposal and to anticipate the opponent's demands. The better you anticipate, better would be your negotiating skills, which you will be employing at the time of negotiation when it will take place. So, among the most important steps to pre-negotiate preparations are something like your coordinating preparations among persons. Coordination is very important among the persons who are responsible for gathering, who are responsible for gathering information, who are responsible for analyzing those information which have been gathered, and all those information which are relevant to the bargaining process. Here, another thing that is to be touched upon, that when we go for pre-negotiation preparation, another step would be that selection of a chief negotiator, and the composition of the bargaining team members. So on the basis of that, the next step would be your reviewing previous negotiation which has been made, if at all, if any, because it provides some kind of insights into the opponent's bargaining tactics and what are the probable demands. The next step would be that gathering data, and when I say gathering data, that is on internal operations, that is on gathering data on the policies of comparable firms, that is through the wage survey, that is through the salary survey. And the next step would be that you have to formulate proposals. And you have to not only formulate proposals, also you have to set the priorities. So the next step would be to select a suitable site for the purpose of negotiation. So you have to organize the relevant information in a bargaining book for easy access at the bargaining table. So you don't know at what point of time which type of information data is very much required. So the final step would be that you have to notify the opponent the intent to bargain by serving the required notice. So, what I would like to mention that one of the most difficult aspect of your collective bargaining process, that is to determine appropriate bargaining units. The principle that is to be followed to make the entire process smooth is that there should exist a community of interest among the employees, and those employees to be represented for the purpose. Otherwise, if you have a single bargaining agent, that would find it impossible to represent all the interest of the parties concerned to it, and that too the interest equally well. So the first step in the collective bargaining process is establishing some kind of relationship for ongoing negotiations and the formulation of agreements, and those agreements covering certain conditions in the workplace. So it is quite obvious. It is quite obvious that a great deal of effort can go into the process and uh, of establishing a collective bargaining relationship. So obviously, it is an anxiety producing process, and each step may involve a bitter conflict between the parties. So sometimes you will notice that the conflict escalates to litigations, and sometimes also it even spills over to violence. So hence, one of the objectives should be your promotion of rational relation, promotion of harmonious relation between employers and the unions. The second step in the bargaining process, in fact, relates to the scope of bargaining. That means the matters on which to bargain. So it consists of three broad categories of items. One thing that is your subjects over which you may say bargaining is mandatory. The second is your subject, which is considered illegal or prohibited, and the subjects on which the bargaining is permitted but is not required. So, in case of subjects when we are talking of which are mandatory, so the relevant salute or the common law that we are talking of makes it unfair labor practice, or there will be a breach of good faith to refuse to bargain over them. So, on the process, the second category of items in the scope of bargaining is practices and very much considered illegal or prohibited. So these are the matters that cannot be bargained under the law. So filing between the two categories, as I told you. So in that case, what is going to happen that you look for the items upon which your bargaining is permitted but not required. So either side may refuse to discuss such a matter. So to do so is not considered as a kind of breach of fair practices or a good faith. So the third step would be in the bargaining process is careful restructuring, because we have seen that many observers, they come, they go, and they agree with some structural aspects that are crucial in facilitating the ability. So the to if you say that how do I facilitate the ability of reach agreements, then so many observers, they agree that some of the structural aspects are crucial, no doubt about it, in case of financial or facilitating the ability to reach um, agreements. But having said that, the personnel department should take the initiative of forming some kind of negotiating team, and the team consisting of two or three members. And besides the industrial relation experts, that way you have to count. So the management team should be included as a part of representatives of the department. Similarly, you have a personnel specialist is also there. And apart from that, some of the competent and someone who is competent to assess the various proposals, who are assessed to maintain various counter proposals. So bargaining process or the bargaining team should also be balanced in the sense, in terms of the number of individuals who are present. So both the sides, to certain extent, should agree in advance. And as a matter of fact, when both the sides they agree in advance, so obviously we look at the sides should agree in advance on the timing aspect, on the location aspect, on the length of your bargaining sessions. So you have to prepare an agenda. Agenda should be prepared, indicating which items can thought to be uh, taken off first. Because earlier I had told you that you must decide the priority part. So your economy and your non-economy. So economic decisions may be made as to whether the trial and the whether you must be able to treat each item in the sense that separately and to seek to bargain the entire package at once or at one go. So the task of management team, when we look at, this should range from your formulation of management's charter of demands and to fulfilling and the or you can say demand to the full participation in the actual bargaining. So this one is also very much actual bargaining sessions, and above all the preparation that which you make, that is of the draft resolutions and of the settlement then, and then finally the readiness will call for some kind of negotiation. So obviously, uh, when we look at based at Bhubaneswar, but looked at the uh, other aspects in operation in the organizations. Obviously, in the absence of a good faith, bargaining has been found maybe as a unwillingly or unwillingness to make other proposals. And apart from that, also the constantly changing position, and that too in, you can say, a position in the higher. Then in that case, what is going to happen that the unwillingness to make the counter proposal, that is why you are not willing to. Secondly, what will happen that the counter constantly we look for some kind of changes in the positions, and obviously when we look for the changes in the change positions, and another aspect that is to be seen, that the true of delaying tactics and withdrawal of concession after they have been made, or you may say unilateral actions over topics of bargaining has to be seen, and refusal to furnish all necessary data for the purpose of negotiation. And if we look at the steps to improve upon the aspect of or to improve upon the process of collective bargaining as such, obviously you'll have you can say good beginning for the very purpose, because unilateral actions over topics of bargaining, then you will have more freedom which was not earlier there. So finally when you go for refusal, it is the refusal of furnished necessary, furnished data for the purpose of negotiation, for the purpose of steps, for the purpose of going for some kind of mechanism to improve process of collective bargaining. Obviously, if I want to improve the process of collective bargaining, then what are they? They are as follows. Maybe you start with the process, that they begin the process of negotiation with proposals, and don't begin the process of uh, negotiation without not having any kind of demand. So that is why always we try to avoid taking public positions. Always we try to avoid taking public positions for the organized proposals, organized proposals. And in that case, when we are going for, we have to also avoid taking public positions for the general concept of viral is also very much there. So the viral of your conflict of interest will be disseminated. So you give your negotiator proper authority to bargain, because unless he has got the authority to bargain, you will not be able to deliver goods adequately. And one thing that must be kept in mind, that is uh, you have to avoid unnecessary delays in the beginning of negotiations and in conducting the entire process. The aspect that you have to insist on offering the facts, you have to insist on the properly that you are talking of the arguments. So market plenary of proposal is there to enhance the opportunities that we come across, how do we encash that and compromise, and for that purpose one has to be ready. And you provide all kind of ways, you can say, you can be prepared to get results published. So in many cases what we have seen, that preserve the good manners and keep discussion focused on that. And in fact, when we are talking of all these things, you have to prepare a stand for a long and hard strike or a lockout, as will be decided from time to time in the organization. Now coming to the settlement part, and obviously when we talk about settlement, it is defined in section 2B of the Industrial Dispute Act 1947, where it envisages two categories of settlement. What are they? One is the settlement which is arrived at in the course of conciliation proceedings. That means which is arrived at with the assistance of conciliation officer, which is arrived at the assistance and the concurrence of the conciliation officer. One settlement. The second settlement is that an agreement which is made between the employer and the workman. The agreement is very much arrived at. Otherwise, in the course of conciliation proceeding, that is to be seen. So, to be valid, the agreement under the second category, that is the agreement between the employer and the workman arrived at otherwise than in the course of conciliation proceedings, should be in writing, and it must be signed by the parties, there too, and whatever copies should be sent to an officer who has been authorized to uh, um, for this purpose by appropriate government and your conciliation officer. So every settlement, that is why is an agreement, though every agreement is not a settlement. And to be valid, we always look for the thing to be in writing, signed. So settlement arrived at otherwise than in the course of conciliation proceedings, that is binding only on the parties to the agreement. So it doesn't bind anyone, if at all, other than the parties thereto. So settlements that is arrived at in the course of conciliation proceedings under the Act definitely will be binding on all the persons employed in the establishment, in fact, to which the dispute relates, on the date of the dispute occurred, and all persons who become subsequently employed in that establishment, that will also enforce upon them. So there is one Herbertson Limited, that is liquor company, versus Workmen of Herbertson Limited, and the case was there in the Supreme Court, and the Supreme Court has laid down certain principles regarding settlements. The principles regarding settlements are as follows, like you can talk about the numerical strength of the number of unions which is party to the settlement, and the party has an important bearing as to whether the settlement is accepted by the majority of the workmen or not. And here, the settlement reached in the course of collective bargaining is very much entitled to due weight, and weight is to be given, and consideration must also be provided for. And the settlement has to be considered, no doubt about it, in the light of the conditions, in the light of the conditions that were forced maybe at the time of your reference. So conditions prevailing at the time of reference will only be admitted. And the principles of when we are talking of give and take, if you have been invited for a lunch, somebody must have sponsored that lunch. So here what is going to happen, that the principle that you are talking of, the principle of give, the principle of take, um, these are all during the negotiation process. Negotiation is to encourage, and when you are talking that the negotiation is to be encouraged in the interest of the general public, general peace, apart from their well-being. So the settlement has to be taken as a percentage when the labor has gained in the matter of wages, labor has gained. There is no, I would say, reduction. There is no reduction in dearness allowance. So it cannot be said that the settlement as a whole is unfair. Settlement as a whole is very much not just, rather unjust. So a voluntary settlement has to be seen, has to be distinguished from your adjudication, because the question is whether or not that a particular settlement is just, and that particular settlement is, you can say, fair, and that particular settlement is not at all to be decided by applying for the principles of adjudication. So we always look for the settlement should be whole, adjust, and the aspect of um, other things which will not be unjust. So voluntary settlement has to be distinguished from adjudication, because the question is whether or not the settlement is just, and not to be, um, you can say, decided by simply applying the principles of adjudication. So there may be several factors which one can talk about, the influence parties and the parties to come to a settlement as a phrase that endure in the course of collective bargaining. So by the settlement of the labor, it may scale down as it claims, because many a times we need to scale down its claims and score. The purpose is that in some other aspects which are severe necessary expenses in certain litigations. So once coordinated, in fact, is established between the employer and the labor in arriving at a settlement, they are working on it, which operates well for a period of certain period. You take it on your own, but that should be in force. So there is always a likelihood that we must also say that of a further time, that means advance in the shape of improved emoluments, and those emoluments only for voluntary settlements. So there is no that you have to decide under compulsion, because the fact remains that when you do something for a period of um, some period, and that too that must also be enforced. So there is always a likelihood that further advance in the period is not at all good. And how do I save of the improved emoluments by voluntary settlements, and avoiding some kind of friction not to take place, unhealthy litigation not to take place. So in the process, the uh, quiescence of settlement, your accept of settlements with the court tribunals should enable the aspect of encouragement. So it is spirit of the settlement has to be judged by not only um, by the yardstick adopted in scrutinizing and scrutinizing an award or an adjudication. So it is a kind of self-assessment. It is a kind of settlement, and the settlement should not highly be unconsciously, or you can say grossly unjust activities. So settlement should not be seen as bits or the piece, because the fact remains, when we're taking the settlement which is signed by the large majority of the workmen, it holds good. Even the same is challenged by the Ministry of Workmen. So if we look at the case of Tata Chemicals, obviously there was a settlement between management and the uh, union. And in the process, what is going to happen that uh, when you go for settlement between the management and the union, representing the majority of the, you can say, of workmen, those who are those who have arrived at the direct negotiations about the work club, or you may talk about the Supreme Court held that the minority union that we are talking of can valiantly raise an industrial dispute, and section 2K of the act as regards the contention of the management, but that members of the unionity, where union we are talking of, but the fact remains that things will get delayed. So, in fact, when we are talking of the settlement which is arrived at, otherwise than in the course of your conciliation proceeding, very much binding only on the participant, on the parties to the agreement. Nobody other than the parties will deal with that. The second thing which is coming to my mind, always the uh, talking of some kind of settlement, and when the settlement cannot be weighed in the golden scale, and the question arises whether it is just, question arises whether it is fair to be answered on the basis of certain principles, and on the basis of different from those which came into play, where you find that industrial dispute is under adjudication. So if the settlement has been arrived at by a vast majority of workmen, and that too with the eyes open, and that too was also accepted by them in its totality, and then it must be presumed that it must be presumed to be fair, it must be presumed to be just, it must be presumed that something not liable to be ignored merely because of small number of workers were not present, so it is or refused to accept it, or you can say because of the tribunal, though that the workers they deserve marginally but higher emoluments than they did. So in this case, one question arises, then you go for agreement, then collective agreement, then what is that collective agreement all about? The range of subjects that we are talking of, which may be covered by collective bargaining or collective agreements, is very wide. Some agreements may be short and they deal with only limited matters, they deal with only a few matters. Many, however, are elaborate codes which cover a great many aspects of your industrial relations. In some respect, what they do, they constitute a kind of industrial legislation regulating the conditions of employment of a vast number of employees. So you can prepare a list indicating some of the main items which are included in the collective agreements. Likewise, you start with the wages, and wages including your time rates, including your piece rates, including your other incentive payments, and what is the procedure for fixing rate, and what is the procedure for fixing rate, that too for new jobs? What is the procedure for calculation of hours of work? How do you decide over time your shifting working, and where to introduce the rest period? Similarly, you have to look for the annual holiday, the rates of pay for holidays. So obviously sick leave, your leave of absence for other reasons, your seniority, again, the matter of uh, seniority rights with regard to layoff, and finally retrenchment, your discipline enforcement, your training of workers, training of apprentices, and the fringe benefits that we are talking of in the last session. The fringe benefits, when I'm talking of, including your retiral benefits. So establishment of your fair production standards, including satisfactory quality of output and the methods of increasing productivity. So joint consultation procedure must also be mentioned. And apart from that, the methods of settling uh, grievances, the methods of settling disputes, and prohibition has to be there. That is prohibition of strike in between, lockout during the period covered by the agreement. Because there is a duration, when it is a question of agreement, there is a duration of agreements. And when we look at the duration, we always go for the procedure for negotiating a new agreement. And once collective bargaining is there and it has resulted in an agreement, obviously the provisions of the latter are regarded as part of each contract of employment. Whether the contract of employment is given in the written or it is implied, but things will apply to them. So, in that process, under certain law, when we are talking of under certain law of certain countries, in fact, the employer has no obligation to apply the terms of the agreement to any worker in the occupation covered, uh, which is not the member of one of the trade union, or which is, you can say, no obligation to apply the terms of the agreement to, or any worker in the occupation covered which is not a member of one of the trade union, uh, and which negotiated the agreement. But in actual practice, what will happen? Do you know? It is usual to differentiate in this way, and the terms and conditions, the terms of agreement are generally prepared to all workers in the occupation covered by it. So in the course of application, when you apply, in the course of application of the agreement, you have disputes. Disputes may arise over the interpretation of its provisions, and this may happen because of your wording of a clause in that is clause is ambiguous. So here, what is going to happen that some employees may apply the clause in one way, whereas you have representatives of the union. They have been there. They have you have intended another interpretation. So to resolve this problem, many agreements which will contain clause specifying in the procedure and to be adopted. So if at all dispute arises over the interpretation, then law will take its own course. And apart from that, also we look at the rules, and when we look at the rules governing the collective bargaining itself, they're all laid down in the law of many countries. For instance, you may say, in order to valid an agreement, you may have to give it in writing, and the duration is specified. The rights of the party is clearly stated, obligation of the party is clearly stated. So in many countries, the parties are free to make their own, I would say, collective bargaining arrangements, because without having to comply with the government regulations, probably you are usually equally both free to decide for themselves the contents of the collective agreements, provided the terms of contract, when we are talking of, must not be less favorable for the workers when he's there. Obviously, provided that the terms of the agreement must not be less favorable for the workers than that, or the fact remains the standards laid down on other different schools. So in that case, the law may require that every collective bargaining to specify the obligation, so that the parties of one employment obviously can contain clauses respecting its implementation, clauses setting of a joint bodies to deal with compensation, and finally respecting the implementing. And in fact, when you are talking of this implementing, it is more than your planning, because respecting its implementation and setting of joint bodies to deal with the difference over your interpretation. So also the law may have joint bodies and to deal with differences from A, and always try to provide provisions for extending their applications. And we have to be committed for the very purpose. And in this case, it is the income that we are more concerned about. And in some countries, this extension even to a whole country, they can be affected under the legislative authority that you can talk about. But in India, when we are talking of collective agreements, you apply to all the those workers who are covered by a particular settlement, which is irrespective of your of their, you can talk about individual union status, because conflict resolution process are provided by the Industrial Dispute Act 1947. But however, since state government have the autonomy to make the enactments, obviously these are the variation in the management practices and which is taking place across the globe. So the practice that we are talking of, that way in India, the collective bargaining contracts can be enforced under the Section 18 of the Industrial Dispute Act 1947. And finally, you'll have some kind of settlement, and the settlement is arrived at between the workers and the employers. So appropriate government may refer the dispute, and when they refer the dispute over a breach of contract, and in that case, the employers have to visit labor court or industrial tribunal for the purpose of keeping some kind of documentary evidence. So if I take a kind of extract from ILO, which has laid down certain guidelines on collective agreements in its recommendation 91. So that was a collective bargaining A and the Workers' Federation manual, that is B. So collective bargaining machinery that we are more concerned about, appropriate to the conditions which are existing in the each country, should be established. So in this case, by means of government, by means of laws, by means of regulation, as it may be appropriate under national conditions, and to negotiate and to conclude and to revise, all of those things should be there, and that must be reinforced. Organization method of operation, method of functions for the purpose of manufacturing, and that operation and the functions of the machinery should be determined by the agreement between the parties or by national laws or regulations as may be appropriate under national conditions. So collective bargaining should bind the signatories thereto, and those you can say on which we have the agreement is very much concluded, but the employers and workers, they are bound by a collective agreement, but this should not take to be able to include, I would say, be able to include in contracts of employment stipulations. So the stipulation, we would say, becomes a in a contract of employment which are more favorable to the workers than those prescribed by the collective agreement. I'm of the opinion should not be regarded as your contrary to the your collective agreements. So the stipulation that normally we quote, the stipulation of collective agreement, should also apply to all workers employed, or engaged in the undertaking which is covered by some kind of agreement which was there, unless the agreement specifically provides to the contrary. So your disputes arising out of the interpretation of a collective agreements, in fact, it should not be submitted to an appropriate or maintaining appropriate procedure. So you have to be more vigilant for the purpose of settlement established either by settlement with the parties or settlement by the you can say by the laws, or settlement by regulations as may be appropriate under national commissions. So after this also what we have observed, that the supervision of the application of the collective agreement should also be ensured by the uh, employers, should also be ensured by the workers of the organization. So, in the process, what is going to happen that you have to prepare a drafting of memorandum. And when you prepare draft, when you prepare a draft, so you have to draft the agreement. So when you go for drafting the agreement, so some precaution which may be taken in drafting the agreement so that it could be implemented without much difficulty. So before commencing the drafting of a collective agreement, what is the job of the draftsman? Draftsman should try to conceive the whole design of it, A to Z. So care should be taken to see that nothing is omitted or nothing is admitted at random. And one has to be not only vigilant but also conscious regarding the technical term, regarding the legal terms used should be precise, should be accurate, and must also be understandable. And the agreement should be ready and intelligent. That means when I say the agreement should be should be readily intelligible to layman, and there should not be any ambiguity, and a well drafted document should be very clear to any person who has a basic knowledge on the subject matter, and the draftsman should always himself try to satisfy as to what means to say, what he does not mean to say. So what he needs not say. So the choice of word, articulation of the word should be appropriate to every person's the machine, as a result of which let me see that how it can be made. So words should always be used in a way in the same sense with the active voice, and that is preferable because active voice is preferable to passive voice, and the names to be reflected over there, the names of the representatives, their designations, and the organization to which they represent, organization to which they belong to. And you have the reference of the union's request for the purpose of collective bargaining. So preamble is there, the purpose of the agreement is also there. So always you must refer, because reference of all demands that we are talking of, and the references of the union's request also for the collective bargaining preamble, the purpose of the agreement, references of all demands which are coming, irrespective of your whether they have been dropped or they have been withdrawn or they have been cancelled. So what is the period of operation, that also need to be mentioned over there. So notice period for the termination of agreement has to be solved. So in the process, the date of implementation of various issues, various times covered in the you can say in the agreement, and the provision in conformity with the law, because collective bargaining, I must tell you, as far as possible, should be self-explanatory. So collective bargaining dealing with your subject number of subject expert could be made clearer. So if the document is divided into logical order, so in the first part, right, then the progress, then the customer, and in the process, the administration of the contract has to be taken into consideration, which has got three basic parts. One is the introduction of the contract after it is signed by the parties. And training of the concerned executives, should be taken with all serious note. And the contract alteration and the contract revision, if at all required during its term, including possible reopening of negotiation on specific issues. And finally, the third basic part will be your contract administration. So the success of the collective bargaining definitely will depend upon the success of the entire process. So we must look at what are the conditions for success of collective bargaining, and in that case, the union participation in the collective bargaining process must be very strong. That is democratic or enlightened. It must be democratic. It must be enlightened. So the weak and the fragmented state of the union and the process, the smallness and the instability of their membership, or is there rivalry, and the company formed and nominated or dominated their trade union are some of the reasons for the underdeveloped state of collective bargaining. So one of the principles for establishing and promoting collective bargaining is to give voluntary recognition. Who is going to receive voluntary recognition? That voluntary recognition to the trade union. So trade union, after receiving voluntary recognitions as one of the contracting parties, so it may also have the positive benefit of improving industrial relation. It has got the positive benefit of improving production. It has got the positive benefit of improving the productivity. There should be willingness to give and take by both the parties, and better understanding on the part of both the parties, an agreement, and to make collective bargaining work. And the trade union should remain refrain something from putting forward exaggerated demands. Both the parties must realize that the collective bargaining, when you are talking about an instrument, negotiation are by their very nature, and in the process, the necessity that both the parties should refrain from the putting some kind of forward exaggerated demands, because both the parties must realize that the collective bargaining negotiation are their very nature on the part of your compromise process. So emphasis must also be given on the accommodation part rather than the conflict part. So an emphasis on accommodation rather than conflict is necessary. So the whole atmosphere, if we look at the collective bargaining, gets vitiated, and the relations become bitter, strained, and when you go for the negotiation, it's still more difficult. So that is why it would be appropriate to mention that your trust and openness are very, very essential for meaningful discussion. And apart from that, the collective bargaining usually takes place when there are differences between the parties on certain issues for better clarification of those parties. And effective collective bargaining presupposes an intelligent understanding of both management and the union of needs, of aspirations, of objectives, of problems of the other party. So union leaders must have full knowledge of the economics of the plant, or the economics of the industry concerned, and at the same time, management must have to develop some kind of awareness of the nature of the union as a political institutions which operating in an economic environment. So finally, what we look at the effectiveness of the collective bargaining. It cannot be attained without maturity of leadership on both the sides of the bargaining table. So that is why the negotiators, they play a bigger role, and that should have such they should have such qualities. The negotiators should have such qualities like your experience, qualities like your skills, qualities like your intelligence, your resourcefulness, your honesty, technical know-how, and they must have the capacity to distinguish between the basically important issues and trivial issues. And with this, we come to an end of today's session. Thank you very much. Have a nice time.